Hi, y'alls. Let me check how I did on my steps today. I walked 11,376 steps. Yay, made goal. So Jones versus Abel got a new filing today, and it is a motion to dismiss. And so, not the whole lawsuit, just count 8 against the Doe's parties. Because apparently Stephanie Jones had agreed that she was going to not, um, you know, she wasn't going to, what's the word? She was going to dismiss that claim if she couldn't find people to add by July 10th. Well, she never did. So in essence, she agreed to it. Hi, Gloria. Hi, Carrie Bruce. Hi, Christina. So we're going to be reading all of that. So there is, it's 15 pages. The first document that we're going to look at. Hey, Gelth Walker. Who are you warring against? All right. Stephanie Jones and Jones Works. So this is a memorandum of law in support of the Wayfarer party's motion to dismiss the 8th cause of action for defamation and the John Doe defendants. So I'm passing all this stuff. So introduction. Hey, Kenny and Pam. Wayfarer Studios, LLC, Justin Baldoni, Jennifer Abel, and Melissa Nathan, the Wayfarer parties, respectfully submit this memorandum in support of their motion to dismiss the John Doe defendants and the 8th cause of action for defamation, which is directly solely against John Doe's 1 to 10, pursuant to Rules 41B, 21, and 4M of the Federal Rules of Civil Procedure, and the court's inherent authority to dismiss for failure to prosecute. The John Doe defendants and the 8th cause of action should be dismissed with prejudice because plaintiffs Jones Works LLC and Stephanie Jones have failed to identify, name, or serve any Doe defendant, despite more than 19 months having elapsed since this action commenced, 15 months since the court-ordered deadline to amend the complaint, and 9 months since fact discovery closed. Plaintiff's sole attempt to cure the deficiency, a motion to amend the complaint to substitute a named defendant on the 8th cause of action, was denied by this court's opinion and order dated March 26, 2026, for lack of diligence, undue delay, prejudice, and futility. The court found the defamation claim time-barred. After that ruling, plaintiffs agreed to dismiss the 8th cause of action and the Doe defendants no later than July 10, 2026. Plaintiffs broke that promise, failing to file the agreed dismissal and leaving the Wayfarer parties to seek the relief plaintiff promised to provide voluntarily. Gelth Walker, great job. 12,358 steps. Awesome. Hi, Gloria. Oh, wait, I said hi to you first because you're the first person here. But hi again. You had said she thought BL wouldn't wave the white flag and settle, so she thought she'd win via Liar Lively. Gelth Walker said, as for why I'm gearing up for war, I'm going up against my real estate after they lied to me yesterday over the cameras and my chili plant being stolen. Oh. Well, I hope it gets resolved with no casualties. Hi, Mari. Pam said, I wonder if SJ is going to toss BL under the bus. Really surprised neither turned on each other. Um, mm, I'm trying to remember how to pronounce the name. Is this the one that said it's like Tyra but with a K? Kyra? Are you the one that told me that, or is this a different name? There was like three people that kind of had the same name, and I was like, am I thinking of the right person? Okay, great. Hi, Kyra. It said nice to tune in. I'm late packing, so nice to have your live to pack to. Oh, yay! I'm glad you can pack to this live. Hi, Alexandra. You just finished making banana bread. That's awesome. Alexandra, what are we reading? We are reading the motion to dismiss by the Wayfarer parties, not the whole lawsuit, just the eighth count on eighth cause of the eighth cause of action. I'm sorry, the eighth cause of action against the John Does. So basically, Stephanie Jones had said, "Hey, I will voluntarily dismiss this claim if I don't add a name by July 10, 2026. Well, she did not add a name. And so they're saying, hey, she already had said she was going to agree to this voluntarily, but she's reneging on it. And so we have to bring it here. Hi, Moon Hand Healing. Mari said it's interesting that Blake claimed there was an untraceable smear campaign. All that she was trying to do, while she was trying to do an untraceable information theft. Untraceable only works for her when she's doing it. Pam said this is basically just cleaning up the docket. No, well, I don't know. I mean, I think their whole purpose is like saying you don't have anybody to sue for this alleged smear, like these smear websites for your, like, as much as people talk as if there's a definitive proof of who started these smear websites, there really isn't any proof. And that's why she can't put somebody. Yeah, this is the stuff, the Jones versus Abel case. Yeah. That's correct, Christina. Alexandra. Oh, yeah. Is this a current motion to dismiss, or was this for the SJ versus Abel lawsuit? Yeah. This is for Jones versus Abel lawsuit, but only the eighth cause of action. Gelth Walker said, hey, Bocce, if this does get to QCAT, what's QCAT? Court, you want to cover any of the legal paperwork? If I get it, I will redact as needed, but might be a bit of side fun. Unfortunately, Gelth Walker, I don't think I can. I'm really focused on getting this particular thing done. Like, I have a specific goal that I have to do. And, you know, with people moving on from this case, like that, the check is getting smaller and smaller with this particular channel. But I'm still interested in following this, even if it decreases to almost nothing. Because I'm just a person that needs to see things through. Hi, Thunder Snow Dog. Yeah, Christina said, I think they were supposed to identify Doe defendants by a certain date, but did not. That is correct. They did not. And she had said she was going to voluntarily give this up. Oh, Queensland Civil Administration Tribunal. Why? How expensive are those things, Gelth Walker? The eighth cause of action is now a legal nullity. It asserts a time-barred defamation claim against unnamed and unserved parties whom plaintiffs have failed to identify, despite the court-ordered amendment deadline, the close of fact discovery, and the agreed dismissal date. Allowing the claim to remain on the docket serves no legitimate adjudicative purpose and imposes concrete prejudice on the Wayfarer parties by preserving the prospect of renewed discovery and continued defense of a claim that the court has already found futile. Accordingly, the court should dismiss the eighth cause of action with prejudice under Rule 41B and its inherent authority, drop the Doe defendants under Rule 21, or dismiss the claim and the Doe defendants without prejudice under Rule 4M. Um, oh, it's free for you. That's why I'm willing to share the info because it's interesting and no cost to you except an email. Oh, gotcha. So that was like you were joking. I am such a literal reader, Gelf. Like literal. I somebody has to like put in parentheses sarcasm or joking, or I will read it, read anything like as an actual thing. Christina said I did read some of this earlier today, but not all of it because I was hoping you would go live. Bocce is way more fun when we are all together. Oh, yeah, true. I wasn't sure. Carol had actually texted me and it was like, "Are you gonna go live tonight?" Because she let me know about this. And and I said, "Oh, did something get filed?" You know, I've been working all day, so I didn't get a chance to. I'm just so thankful for Carol. Carol gives me a heads up, heads up, and even if I totally forgot what I was gonna say. I totally forgot. I hate it when I do that. Oh, speaking of Carol, hey, Carol says I'm here just doing chores. Oh yeah, so like I'm so thankful for Carol because she lets me know when things are out there, and if for some reason she doesn't, somebody eventually will let me know, because I might not be aware. Um, Gelth Walker, have I seen the backlash for the cosmetic company Hayden did an ad for? Um, I no, but I had a feeling. I had a feeling that they would experience backlash after that interview and after her death, where she shared that they dropped her after she shared her struggle with depression or postpartum depression, and she thought there were many things that they could have potentially dropped her for, but like that was not the one the one piece of action that she expected to be dropped for, because she wasn't trying to be controversial in sharing her experience of postpartum depression. So I had a feeling that there would be some backlash now that she's passed. Um, Pam said I check Reddit daily, so I kind of know if a live may happen. I mean, typically, most of the time, I have lives uh, almost every day. It's very rare that I don't. Um, Alexander said Neutrogena started getting backlash since May when Hayden shared in May on Jay. I think it's Shetty rather than Sherry, but I might be wrong. Podcast what happened to her, but now there is a resurgence of backlash with her passing. Yeah, I had a feeling. Um, and I mean, it's not a great look for Neutrogena to do that. Out of all of the controversies that she's experienced in her life, that might have been like not the best one to say like, oh, that's where we draw the line, you know. Anyways, so statements of fact. Plaintiff Stephanie Jones and Jones Works LLC commenced this action in New York. Um, Supreme Court, New York's County on December 24, 2024. The complaint names as defendants Jennifer Abel, Melissa Nathan, Justin Baldoni, Wayfarer Studios, and John Doe's 1 to 10. The action was removed to this court on January 27, 2025. That would have been Chad's birthday. The eighth cause of action, titled Defamation against Defendants John Doe 1 to 10, alleges that unknown individuals created and published two websites that allegedly contained false and defamatory statements about the Jones parties, StephanieJonesLeaks.com and StephanieJonesLies.com, as well as subsequent disparaging social media accounts. The defamation claim is stated solely against John Doe 1 through 10, and no named defendant is alleged to be liable for the eighth cause of action. This court's initial case management plan and scheduling order set April 18, 2025 as the deadline to move to amend or join additional parties. Fact discovery proceeded and closed on September 30, 2025, except for certain depositions pursuant to stipulation and order, without plaintiffs identifying or serving any John Doe defendant. Subpoenas were issued but failed to yield the identity of any Doe defendant. On December 8, 2025, nearly 8 months after the amendment deadline, plaintiffs moved for leave to amend the complaint to, among other things, substitute a single defendant, Melissa Nathan, for the Doe defendants in the eighth cause of action. By opinion and order dated March 26, 2026, this court denied the motion in its entirety. The court found that plaintiff failed to demonstrate good cause under Rule 16b for the untimely amendment, exhibited undue delay and a lack of diligence in pursuing the identities of the Doe defendants. It further found that the amendment would cause undue prejudice and that the proposed defamation claim would be futile because it was time-barred under the 1-year statute of limitations applicable to defamation claims under New York. Notably, the court found that plaintiffs did not request documents relating to the allegedly defamatory websites in their initial document requests served on March 6, 2025, and did not propound website-related discovery until July 2025, which was after the 1-year limitations period had already expired. Hi, Donna. Is there anyone else that came in that I missed? Okay. On April 14, 2026, the Wayfarer parties asked plaintiffs to dismiss their eighth cause of action, given the court's amendment order and plaintiff's failure to serve any Doe defendant. On June 29, 2026, plaintiffs finally agreed to dismiss the eighth cause of action for defamation and the Doe defendants by no later than July 10, 2026. Although the agreement was confirmed in writings, plaintiffs reneged on their commitment and have not filed the promised dismissal, requiring the Wayfarer parties to file this motion. The eighth cause of action and the John Doe defendants should be dismissed. Rule 41b supplies authority to dismiss the eighth cause of action with prejudice for failure to prosecute. Rule 21 provides an independent procedural mechanism to drop the Doe defendants, and Rule 4m requires dismissal without prejudice when a defendant has not been timely served absent good cause or a justified extension. The court also has inherent authority to dismiss for failure to prosecute. Because the Doe defendants have never been identified or served, and the eighth cause of action is the only claim asserted against them, these authorities permit the court to dismiss the eighth cause of action. Dismissal with prejudice is warranted under Rule 41b. Rule 41b of the Federal Rules of Civil Procedure provides that a court may, in its discretion, dismiss an action or claim based on a plaintiff's failure to prosecute or comply with the federal rules or a court order. Plaintiffs have the ultimate obligation of moving the case to trial, and dismissal is warranted where there is a lack of due diligence in the prosecution of the lawsuit by the plaintiff. A plaintiff has a general obligation to prosecute his case diligently, and if it fails to do so, the court may dismiss the action under Rule 41b for failure to prosecute. Courts routinely dismiss claims asserted against Doe defendants for failure to prosecute pursuant to Rule 41b. In considering whether dismissal of a claim for failure to prosecute with prejudice is warranted, a district court considers the following non-exclusive factors, none of which is dispositive. 1. The duration of the plaintiff's failure to comply with the court order. 2. Whether the plaintiff was on notice. The failure to comply would result in dismissal. 3. Whether the defendants are likely to be prejudiced by further delay. 4. The balance between the court's interest in managing its docket and the plaintiff's interest in receiving a fair chance to be heard. And 5. whether the court has adequately considered a sanction less dramatic than dismissal. These factors strongly support dismissal of plaintiff's eighth cause of action with prejudice. Plaintiffs failed to prosecute the eighth cause of action for more than 19 months from the commencement of this action on December 24, 2024, through the filing of this motion on August 13. They neither identified nor served any Doe defendant during that period. District courts in the Second Circuit have found delays of 6 to 10 months sufficient to support dismissal. A delay of more than 19 months far exceeds delays that courts have found sufficient for dismissal and supports a presumption of prejudice. Moreover, the prejudice is concrete. The Wayfarer parties have litigated through the close of fact discovery and face the continuing burden, expense, and uncertainty of defending a claim that plaintiffs have not pursued and that the court has already found futile. Keeping the claim alive would also risk renewed discovery and further delay despite the expired limitations period. Significantly, plaintiffs refused to withdraw their expert Brian Horton, whose sole purpose is to testify regarding the alleged creators of the Jones websites, which are relevant only to the eighth cause of action. Further, plaintiffs refused to withdraw their damages experts' opinions and testimony arising from alleged harm caused by the alleged defamation asserted in the eighth cause of action, including alleged defamation based on the Jones websites. Here's the thing. Brian Horton's expert report still does not prove who is the person. They can have patterns, they can have all these different things, but who is the actual person? Who are the people? That's I think that's the difficulty. You can put a bunch of links together and say this X, Y, Z, but there is no invoice. There is no, well, I guess maybe that's when Blake will say, it is untraceable. That is why. But honestly, nothing's ever truly, in our day and age, nothing's ever truly as untraceable as people think. People can find stuff. And the fact that they've had 19 months and have not, found anybody that they could genuinely sue them for this says a lot. Now, obviously, the way it's discussed by people, it makes it sound like it's already been a done deal. It's already been proven that Jed Wallace is the one who did all these things. There's nothing that shows that. As much as people want it to, as much as people, if that was the case, Jed Wallace would already have been brought into this case. He's not. I hope people get that. Gloria said, I agree with you, Bachi. It does not prove who really is behind it. And trust me, bro, because I said so, it's not good enough to blame somebody. Gail says, sorry, Bachi, stop making me laugh when you mention Horton, then go, who are the people? Oh, sorry. I did it without even realizing it. Hey, Prish. Oh, did you say it the other day, Gelf? And I'm saying it subconsciously now. You win. You do win. All right. Plaintiffs had actual and repeated notice that their failure to identify and serve the Doe defendants, comply with amendment deadline, and resolve the eighth cause of action could result in dismissal. The court's case management plan and scheduling order required any motion to amend or join additional parties by April 18, 2025. The Wayfarer parties warned plaintiffs that the eighth cause of action and Doe defendants would be subject to a dismissal motion. Plaintiffs then agreed on June 29, 2026, to dismiss the claim and Doe defendants by July 10, 2026. That commitment gave plaintiffs actual notice of the precise relief at issue, and defendants any claim of surprise. Plaintiffs nevertheless failed to file the agreed dismissal. Pam said they do in fact not get that it hasn't been proven that it was Jed. I think people, as a person that is very like pattern recognition person, I get the route that they're going, but the reality is they haven't proven anything. And I think sometimes when you cannot prove anything by actual evidence, you have to, and this is I think how they've gone about it, right, is to get that kind of indictment on Jed, like in the court of public opinion. And frankly, I will always say it doesn't look the best. It doesn't look the best for Jed and Melissa and Brian, at least for me. But with that said, even when I say that, I'm like, but at the end of the day, there's actually no proof. Everything I'm looking at is circumstantial evidence at the end of the day. And for some people, that's enough, but that's not and I don't even know if circumstantial evidence is the right terminology, because I don't know if circumstantial evidence is like, is that only for criminal cases, or does that also work for civil cases? I'm not sure. Under the fourth factor, plaintiff's interest in a fair chance to be heard no longer warrants preserving this claim. Under the fifth factor, no lesser sanction would cure this defect or achieve a just result. The court has already found that plaintiffs did not demonstrate diligence before the April 18, 2025 amendment deadline to identify Doe defendants. Plaintiffs did not request documents related to the allegedly defamatory websites in their initial document request served on March 6, 2025, and did not propound website-related discovery until July 2025, after the limitations period had already expired. Significantly, the court has already found that the eighth cause of action is time-barred, and that any further attempt to amend the pleading to identify Doe defendants would be futile. That finding is the law of the case. The law of the case doctrine posits that when a court decides upon a rule of law, that decision should continue to govern the same issues and subsequent stages in the same case. Rule 15C1A permits relation back only if the applicable state law standard permits it. New York requires diligence in attempting to identify a John Doe defendant. Plaintiffs cannot use relation back to evade the court's finding that they did not exercise that diligence and that proposed amendment was futile. Dismissal with prejudice, therefore, is warranted, as it deprives plaintiffs of nothing. Gloria said, alleging someone did something and proving somebody did something is two, and proving somebody did is two different, are two different, something is two different ballparks. Okay. Mari said, not on topic, but isn't it weird that Blake for the second time does a weird self-centered IG story about someone tragic passing? It reminds me of Ryan trying to talk about himself while talking about John Candy. Ryan and Blake try to cash in on others' tragedies, like maximum efforts whole formula. Yeah, I did a video on just like my own irritation with it. And then I was like, do I seem petty? You know, like, am I being petty right now? But it's part of me is like, I just think it's so rich coming from Blake Lively. You know what I mean? I'm not saying that she can't mean it, but it's always that underlying thing of like, be kind because you don't know what other people are going through. And it's like, girl, that was true that's not just true when someone passes. That's true all the time. And yet you didn't live by that. You didn't live by that. And so I can take the truth of what you say, but like, I feel like it's a cop-out. It's like, please don't hold me accountable for the things I did. Just, be kind to me and forget about everything. And I think, I always will say that I don't want Blake Lively to ever like do anything that would be harmful to herself. But I don't think she will. I do think that she believes that she's always in the right. I don't think she sees, you know, anytime she gives a moment to consider that maybe she could be in the wrong, there's somebody quickly to let her, like, to convince her to not do any self-reflection, and truly you did nothing wrong, and there's nothing to learn from this is all his fault, so then she doesn't go into any, like, self-reflection at all. So I just rolled my eyes when I heard about it. I think I heard it from Ellsridge's video. I watched Ellsridge, because I did not go to Blake Lively's Instagram. I didn't see it on there. I saw it on Ellsridge's video, and it just made me. I was just like, whatever, Blake. Whatever. And again, not because I don't believe in the message. I had a professor one time that said, do you love truth so much that even if your enemy spoke it, you could take it? So I can definitely differentiate and still find value in the message, but the messenger, I roll my eyes at, because she could have taken that into consideration when she said what she said to Shasti, right? She didn't know that, like, she had been struggling with fertility. Like, think about your actions that you then didn't even ever apologize for, Blake. Like, it's so rich to be like that. To be like, she may not be rich in money. She may be, who knows? But she's definitely rich in audacity. She's always been rich in audacity. Christina says, yes, circumstantial evidence is fully allowed and commonly used in a civil case. It is indirect proof that relies on logical inference to connect facts rather than direct observation. The law gives circumstantial evidence the same weight and validity as direct evidence. Oh, really? I never realized that. So circumstantial evidence can be equivalent to direct evidence. Is there ever a time that it's not of the same weight? Or is there a particular way where it's not considered circumstantial evidence? Like, is there a standard of when it's finally considered circumstantial evidence so that it could be equivalent to direct evidence? Pam said civil has a lower bar to decide liability than criminal. I think Nag said like 51% where criminal is proven beyond any doubt. Gloria said, I don't pay attention to Blake Lively, so I did not know. Once again, she made somebody else's tragedy all about her. Typical narcissist. Kenny said, it feels like she only says those things to make people think of her a certain way. I don't feel like she really cares that much. I don't either. I'm not saying that she doesn't care about these people, but I don't think she cares. I think she tends to go, ooh, how can I say something here in such a way that people will think about me? But I'm not going to talk about it like I'm talking about me. But they're still going to think it's about me. Because, now my supporters are going to be like, see, like, Blake just wants everybody to be kind. She wants to suddenly kumbaya it. I'm like, she doesn't want you to be kind. Actually, you know what? Blake Lively's like this. Be kind, but not like that. Be kind. Like, remember when Justin Baldoni tried to say a compliment about her and Ryan, and he said, "Oh, that's cute." He said it in a nice tone, not like the way I just said it. And she had the audacity to say, "I think it's more than cute." Like, girl, he just gave you and your husband a compliment, and for you, it's not nice enough. It's not. You have to up it another level. That he had to say, I forgot what he ended up saying. Like, oh no, I think it's amazing. Just to appease your little fragile ego that could not even take a nice compliment of saying that you and your husband are cute. You had to be like, nah, I don't like that. Up it a little bit, another level. So I don't know. She's definitely, yeah. I feel some type of way. Pam says she's not kind or sincere. She's just riding on the coattails of it. Gelf, in regards to Hayden, said, I feel for her family, especially her father, still recovering from the younger brother's death. And now to hear she died. She died of an overdose. I'm sorry to hear she slid backwards in her recovery. I mean, and I feel like, I don't know who put it in my, I can't remember now. Maybe it was like, was it Akasha or somebody else that had mentioned, but that was like a day ago. Maybe it's been more solidified now that it is officially an overdose. I feel like it got officialized, but I couldn't remember. I haven't had an opportunity to read anything lately. Yazzie J718, hello. You said I'm actually awake for alive. Yay. Garth Walker said her death was a massive tragedy. That was the ultimate price to pay for that backslide. But I'm glad someone there had Narcan and did everything they could to bring her back. But it's heart-wrenching. Pam said, I only follow Blake to monitor if her comments ever get turned back on. I don't think she'll ever turn her comments back on unless she knows that the overwhelming comments will be supportive of her. And I don't think that'll ever happen. I mean, she'll have positive comments. It's just not going to I don't know. I don't know. Yeah. Kenny said, I don't take value from things said by hypocrites ever. So you don't find value in the things I say? Because I've definitely been a hypocrite in my life. There's been times in my life where what I want to be about and how my actions sometimes fail it. I mean, I don't know. I don't know if it's possible for people to never have any moment of hypocrisy. Like, I feel like sometimes we all have like standards for ourselves, even sometimes standards for other people that we don't actually live into as much as we want to. Or maybe I just wrestle a lot with like, I mean, I feel like my life is very congruent. I feel like who I am is fairly consistent, but yeah, I don't know. I'm sure. I mean, I don't know. There's definitely things. I feel very Justin Baldoni this moment where I'm like, where he because sometimes when I would read some of Justin's stuff, I'd be like, he's such a self-flogger a little bit, where he like picks himself apart, which honestly was like just the prime kind of person for Blake Lively to like do her stuff on, because he's gonna already feel bad about a bunch of things he doesn't need to even feel bad about. But and then she has well, anyways, okay, I gotta move on because I'm just gonna, when I think about it, it's really upsetting. Hi Kiara. Mari said, right message, wrong messenger. Yeah. Donna said, Blake reminds me of an old saying, don't do what I do what I say. That's, yeah. Gloria said she's very performative. If she thinks it's going to get her positive press or positive interaction with the general public, then she'll say something. If she doesn't think it's good for her brand, nothing. Yeah. Gail said, hearing that a close friend of Michelle's come out swinging in defense of Michelle, stating Michelle detested Blake as a waste of time. I remember when Shannon Doherty had passed away, and before she had passed away, she made it very clear that she didn't want certain people to act like they cared about her or they were close in real life. I think the two people she did not want to act like they were grieving, not to say that they weren't grieving, but to like benefit out of claiming like that they were sad over her death, was Alyssa Milano and Jenny Garth. And I think to that, like, I think about that to this day. Like, she made it clear, like, I don't want these people like pretending like like we were cool in real life, like when I was alive, because sometimes people like jump on something during somebody's death, but Gloria said, I'll be kind to her when she apologizes to the 107 content creators. Where did that go? Which are all women, some of which abuse survivors, and she publicly apologizes to Natasha Heath. I will say that not all content creators were women, but the overwhelming majority were, for sure. Maybe there was just less than a handful that were men, but still. Christina said, I say she is very rules for thee, not for me. Mari says she spoke about her struggles long before she passed, but Blake only showed any interest when she could turn back to herself. Good point, Mari. Though I will say that sometimes that's true of many people. Like, there's commentary along the way, but sometimes really when people pass, that's why people say, like, say what you need to say to people now. Like, they shouldn't hear, like, the first time they're hearing things shouldn't be at their own funeral, because they passed. So like like the things should be said to people while they're living, and that support system, if people really care about somebody, it's like, provide that support. Like, that should be there, even not just when it's convenient, or like when things are too late or whatever. Kiara said, the nerve of Blake to say, be nice. You don't know what someone is going through, as she falsely accused someone of SA and is abusing 47.1 to get fees. Hi, Simply Me 1474. It's morning for you, huh? It is 9:32 p.m. over where I'm at. Christina said, it seems like it was an OD. The boyfriend gave the cops a bag of pills and there was Narcan there, or you, something like that. Gloria said, I think everybody at some point in their life is hypocritical about something, but that's not intentional to be hypocritical, whereas Blake makes it a pastime. Pam said her comments are limited. I think they are filtered to only accept positive ones. Pam, that's actually, if that's accurate, ouch. She has over 4 million people. No, 42. No, not 4 million. That's Justin Baldoni. She has over 40 million people following her. Oh wait, no, it must be based off of, like, she probably filtered it to like people she follows. So let's see how many people she follows. What's her name again? Oh, I'm so, how did I blank on her name for a moment? I'm like, what? Who's this person I'm looking up again? Okay, she's following 827 people. So she allowed 827 people to comment. That's still ouch, because she barely gets any comments, and it's always the same people that comment. So that's kind of even more sad now that I think about it. It's better if she just didn't limit it at all, just straight up close the whole thing rather than show how few people actually comment on her, even though they're capable of it. Kenny said, I don't think changing your mind or way of thinking different. I have a pet peeve about hypocrites. And if I saw you be a hypocrite, I would call you out. I've held myself to things just because I said something about it to someone else. I would appreciate that, Kenny. I think I'm naturally hard on myself. So I probably would have caught on to my own actions and ways and not felt great about it. But that's what people do, right? They call out things. And if you want to grow as a person, you got to be willing to take that. And I think that's something that Blake has struggled with. It's just like there's so many things that she could have taken away from this time that I still think she hasn't. I think she doesn't allow herself to. The people around her don't allow her to, and her supporters don't allow her to. Because I think I think sometimes when you're wanting to prove that you're so right about something or whatever it might be, like it's like not allowing any space to go, where can I grow? This is why sometimes people even push back on me when I say that Justin had things to learn from this too. And people are like, he did nothing wrong. And you don't have to do something wrong to still learn something, because sometimes somebody makes a choice that's just not smart. It's not wrong. It's just not smart. You know what I mean? There's there's decisions I made in life that's just not smart. I wasn't wrong for it. It wasn't but there's lessons to learn from that. Or sometimes there's a naiveness, or not, maybe it's not naiveness even. It's this desire. I see this in Justin. I see it in myself. Is this desire to believe the best in somebody, almost to the detriment of yourself. And so I think there were so many times where he saw the red flags with Blake, and you could see it in some of his texts where he could tell, where he was like, but there's still this desire. If I just treat this person right, this person will, this person has a reputation of being kind of difficult and all this stuff, whatever. But what's celebrity isn't difficult. I can be different. I can, when she was kind of giving him the sob story of all these directors, they don't like all this. I have all of this sadness over these other directors, and he's like, oh, I'm going to be different. I'm totally going to collaborate, and I'm going to do. And she just took him for a ride. It was like, so I hate the fact that some of the lessons to learn is not that he did anything wrong, more than sometimes people are crappy. Sometimes people are crappy. And you can't assume that just because you would never do something, that someone else wouldn't do that to you. And I think there's sometimes when people accuse people of other things that never crossed my mind. And I'm like, how do people even think about that? And it's because it's usually gives people an idea of what they're thinking about. There's just certain things I'm like, I would never think to do that. I would never think to show up that way. You know what I mean? So Christina said, you aren't a hypocrite, Bocce. You are open to changing your mind when additional information is added. I think when I say I feel like everybody's has yeah, I don't know what is the, okay, let me see the definition for hypocrite meaning, because maybe I am putting my own definition of hypocrite into it. A person who indulges in hypocrisy. Okay. Okay, fine. Hypocrisy. Let's look at the meaning for that. The practice of claiming to have moral standards or beliefs to which one's own behavior does not conform. The practice of claiming to have moral standards or beliefs. To which one? You know, I don't know. I don't know. I think that sometimes people have multiple values that sometimes are in competition with each other at one time. Um, and I think, for example, if if you don't personally believe in ever lying to somebody, but let's say somebody is about to kill somebody, right? Let's say that that's the case, and they're asking where somebody is. You know where the person is, and well, I mean, I guess you could just be honest and say you're not willing to say. I guess you don't have to lie in that situation, but like, or I think about during the Holocaust where people hid people, right? And they said, "Are they here?" And they said no, but they were. Like, so I mean, I don't know, but that's not hypocrisy. I guess I'm just thinking about like having moral standards. Sometimes I'm like, sometimes your own moral standards are in opposition with each other for during specific moments, you know, and sometimes certain values supersede other values in a particular moment, but in another moment it wouldn't supersede it. You know, I don't know if I'm making sense. Never mind. I don't know what I'm saying. Gloria said Blake Lively. Whoops, where did it go? Whoopsie. Okay. Where did it go? Where did it go? Where did it go? Okay. Gloria said Blake Lively is not allowed to give anybody else in this comment section or our content creator hypertension. Gelf says, can he call a spade and be blunt about it if you need to? That's what I prefer. And you've always come across that way. So feel free in your next live to give me the finger over it. I mean, and I want to be clear when I say like I feel like I feel like it can be a hypocrite sometimes. I don't actually mean if I change my mind. Like I have a good reason to say something else if I change my mind. But I mean as a core thing. Like if I say I want to be kind and then Blake Lively does some of does her thing, I'm like, am I being unkind? Is it unkind to call that out? Or is that not in opposition of kindness? You know, to be, is it unkind to feel disgusted by it? Because I am. Because I feel like I just it just drips of hypocrisy in the deepest way. You know, it's like it's I don't know. It's always that I don't know. It's like when people say you should be loving, but and I am, but like there's still like are there still lines and boundaries? And I think so. I mean, I don't know. I don't know what I'm saying right now. I better keep moving because I'm like 13 minutes behind on the chat, and I have not finished reading the document yet. Let's see. Mari said Blake has a track record of only speaking up when she can benefit from it. We saw it in real life with It Ends With Us and DV victims and the Me Too movement in general. Weinstein defended her recently. More recently? How recently? When was this? It's not the one where he said something and then took it back and be like, I have nothing against Blake and Ryan. I think they're wonderful or something, whatever he said. Like he would be the best person to be a character witness. Kenny said Justin 100% had things he was supposed to learn, or the situation wouldn't have happened to him. That is the way life works. Christina said, I can see places they went wrong. And I think that's something that Blake Lively supporters don't realize that we're capable of acknowledging. I mean, there's so many things I can acknowledge in regards to Blake Lively and the whole process, and even a feeling like there were things that I could understand where Blake was coming from. However, what Blake did was overreach and tried to make things that were very benign something more heinous than they actually were in context. Like she made people think by the way they phrase things that he was doing certain things, and not just once and then got talked to and then he stopped. It was like a repeated action that he just didn't know how to stop saying sexy. And yet that's not what the evidence shows. You know what I mean? Like everything did stop. Like when she brought up that she didn't like something, he's then, yes, he was hurt because I think it's like this whole probably like what kind of being taken aback by things, but like he respected it. He did not say the word sexy around her. I mean, sexy to her ever again. And she never claimed that he like, there's nothing she brought to say that he did, you know, after June, after that conversation in June, nothing else. Everything she accused him of, she made it sound like it was repeated when it was not. She made the fact that she had several accusations or allegations that she stacked on top of each other, meaning like she put like 3 to 4 things that was one instance, but she made it sound like 4 different situations and that it was like separated and repeated. And there's a lot of deception. Now, mind you, I understand it was her lawyers, the ones that were gouging her, milking her for everything she was worth. But still, like it was very intentional. And also the 30-point document was incredibly intentionally deceiving. And even though I didn't necessarily agree with folks when they said that they thought that Ryan Reynolds wrote the 30-point document, the more I look at it, the more I understand why people think that way. I actually do think that they're probably right. Ryan probably did write the 30-point document. And the biggest sign of that is probably the beginning of every statement saying no more. Only someone like him would be that petty to want to use the name of the organization that Wayfarer advocated to be the nonprofit to partner with. There's reasons why when Blake Lively finally spoke out in support of any DV things, she did not choose to use no more. She chose everything but no more. She didn't want to even use the very nonprofit that was getting 1% of the shares of the movie. That's how much animosity she had towards anything that she deemed connected to him. And I know some people are like, well, that's because he did. No, he genuinely didn't. I mean, not in the way that she portrayed it. And honestly, people are like, well, can you really say that? This is one of the rare cases where I feel fairly confident based off of what we have available to us. That comes from her own words, comes from his own words, comes from other people's words, that I'm like, yeah, I'm fairly comfortable to say that this was a gross misrepresentation. And one of the things that Blake Lively describes herself as is a storyteller. And she is a storyteller. But it's sometimes just a nice way to say that I lie a lot. But I do it in a flowery way, you know. Kenny said life will present you with the same lesson in a different way over and over until you get it. Christina said those mistakes didn't mean he deserved what he got through. What he got through. She is an awful person, and her husband too. Yeah, and I think that's what I need people to understand, that when I say he had lessons to learn from this, it is not saying I think he deserved to have gone through. Absolutely not. Absolutely not. That was, I would never wish that on anybody. Pam said Ryan's worse. He's petty and relentless. 100. I think Ryan is a very insecure individual. And his insecurity makes him act out. And so Kenny said, if we don't learn from the worst things that happen to us, then what are we even doing? Most people don't learn from the good things that happen to them, unfortunately. Hi, Faye Andy. Okay. Where am I? How far back am I here? I'm trying to just scroll through here. I probably need to move on and actually start reading the article. I mean the motion again. But let me make sure I've said hi to anybody new that's come in since this whole thing. It's so funny that tonight I feel like my voice is very like calm. Sometimes like I've been like railing against the machine. And tonight I'm like, hi everyone. And it's like, I don't know how to describe my voice tonight, but it's not like I think the best way to describe my voice right now is like just calm. My voice sounds calm. Okay, so I'm going to go back to reading this. Where am I here? Christina said, you are calm so far anyways. Because the statute of limitations. Theon, hi. Because the statute of limitations on the 8th cause of action expired, plaintiffs cannot satisfy the diligence requirement for relation back under New York CPLR 1024 or Rule 15C1A. And this court has already made those findings. The 8th cause of action is futile as a matter of law and should be dismissed with prejudice. Kyra said, I think in some level he made the decision that he was going to change the world, but was not going to reach that impact where he was. He needed something this ugly to occur for that decision to manifest. I will say anybody else, I don't think could have survived what Blake Lively did. Blake Lively and Ryan Reynolds did. I don't think that anyone else could have survived. But I think because Justin has from all accounts that we've I guess I shouldn't say from all accounts, but like he's a human being, right? Figuring it out, but he's trying. And I think his reputation preceded him as well as her reputation preceded her. And so I think people knew what kind of person she was. And so when she came and said some stuff, people were like, we've seen you. I mean, especially those that work in the industry that are not celebrities, but are in the cast and crew. Now, obviously, she has some people in the cast. I mean, not the cast, the crew that support her, but they're also paid by her. Because remember, that was kind of part of her contract, that she would be able to bring in some of her people. Well, it's understandable that her people would have loyalty to her. She provides the paycheck. But at the same time, doesn't mean that they don't see some stuff too. So, alternatively, the court should drop the unidentified Doe defendants under Rule 21 and dismiss the sole claim against them. Rule 21 provides that on motion or on its own, the court may at any time, on just terms, add or drop a party. Although titled Misjoinder and Non-Joinder of Parties, Rule 21 is not confined to correcting technical joinder defects. Rather, it affords courts broad discretion to shape litigation in the interest of efficiency and justice, guided by principles of fundamental fairness and judicial efficiency. Once plaintiffs have had an opportunity through discovery to learn the identities of unknown Doe defendants but fail to identify or serve them, dismissal under Rule 21 is appropriate. Dismissal is also warranted under Rule 4M. Federal Rule of Civil Procedure 4M provides that if a defendant is not served within 90 days after the complaint is filed, the court on motion or on its own after notice to the plaintiff must dismiss the action without prejudice against the defendant or order that service be made within a specified time. Rule 4M applies to John Doe defendants. A court may extend the time for service, but dismissal is warranted when the plaintiff cannot show good cause or otherwise justify an extension. Plaintiffs cannot show good cause or justify an extension. They had more than 19 months to identify and serve the Doe defendants, missed the April 18, 2025 amendment deadline, pursued website-related discovery only after the limitations period expired, completed fact discovery without identifying a Doe defendant, and agreed in writing to dismiss the claim and Doe defendants by July 10, 2026, but did not do so. Dismissal without prejudice under Rule 21 or Rule 4M is therefore warranted as an alternative to dismissal with prejudice under Rule 41B. In conclusion, for the foregoing reasons, the Wayfarer parties respectfully request that the court enter an order dismissing plaintiff's 8th cause of action for defamation against John Doe's 1 to 10 with prejudice under Federal Rule of Civil Procedure 41B, dropping the Doe defendants from the action under Rule 21, dismissing the 8th cause of action pursuant to the court's inherent authority, or alternatively, dismissing the 8th cause of action and the John Doe defendants without prejudice under Rule 4M. And that's by Ellen. So that's that. Then we have the declaration from Ellen. Which I'm not really going to read. I'm just going to, because it just tells you what proof that they're providing. So I'll just show you the emails. It's from Amir on April 14. Hey, Akasha. How are you? It says Counsel. On March 26, 2026, the court denied plaintiff's motion to amend their complaint, leaving plaintiff's 8th cause of action for defamation regarding StephanieJonesLeaks.com and StephanieJonesLies.com, asserted solely against Doe defendants. Please confirm by close of business on April 15, 2026, that plaintiffs will dismiss their eighth cause of action, given that they have not served any DOE defendant and the court has denied their request to amend. Absent your confirmation, defendants intend to file a motion to dismiss the action against the DOE defendants pursuant to Federal Rule of Civil Procedure 4M. In addition, because plaintiffs have no claim against any defendant related to the websites, the expert opinions of Brian Horton and Joanne Keeling are irrelevant to this action. Please confirm by close of business on April 15, 2026, the plaintiffs will withdraw the expert reports of Mr. Horton and Ms. Keeling. If plaintiffs refuse to withdraw these expert reports, please let us know when you're available to meet and confer on a motion to exclude both experts and the defendant's costs in taking unnecessary expert depositions. As to Mr. Dyes and Jones Works 30B6 witness on February 17, 2026, following the court's order extending the expert deposition deadline to April 30th, you told us you would revert with our witnesses' availability. You have not done so in the intervening 6 weeks. Defendants are amenable to jointly seeking an extension to the end of July for expert depositions. If you are not amenable, or in case the court does not grant an extension, please immediately provide us with dates next week when Mr. Dyes and a 30B6 witness will be available. If you refuse to withdraw Mr. Horton and Ms. Keeling, please also immediately provide deposition dates for those witnesses. Defendants reserve the right to unilaterally notice the depositions given plaintiff's failure to provide available deposition dates since February 17. So that is one of the emails. And then I think this is the email, perhaps. Yeah, the email from Kim. So Kim Zeldin said, Christina and Kristen, this will confirm interesting. Why to Kristen's Blake's lawyer, isn't she? Is she also okay? Okay, anyways. Christina and Kristen, this will confirm our conversation today. Jones and Jones Works will by no later than July 10th dismiss the eighth claim and all DOE defendants. In addition, I ask you to look at your pleading and dismiss claims to which Jones is not a party, e.g., the contract with Wayfarer. We will send out the deposition notice for Dyes today. Tentative schedule, 721 Dyes, 723. Why are their names Dyes and like Killian? Did you notice that? 721 Dyes, 723 Killian, 724 Wagner, all in Los Angeles. You will confirm Killian's availability and we will confirm Wagner's. Horton followed by Ziedman during the first week of August. You will let me know when Horton is available in Los Angeles or otherwise, and then we can schedule Ziedman, who is in Palo Alto, but I can ask him to come to Los Angeles. I will draft a stipulation to extend the time to take Horton and Ziedman by a week. You will have it by the end of the week. Okay, when was that? That was June 29. The previous, the 7 days beforehand, Kim had said, Christina and Kristen, this will confirm our conversation today on Friday, June 26th at 11 a.m. p.m. PT. We will have another call, at which point you will be prepared to discuss the issues set forth in Amir's emails of several months ago. Considering Judge Lyman's order denying the motion for leave to amend, do you intend to withdraw Horton and Killian? Please be prepared to substantiate your claims that the website is relevant to any of the remaining claims. Is plaintiff planning on dismissing the eighth cause of action given Judge Lyman's order, or will a motion be necessary? If you do not believe dismissal is warranted, please be prepared to discuss why that is the case. The parties will be prepared to schedule the expert's deposition. We will schedule the depositions of the 30B6 witness to take place remotely, and the depositions of the experts will be scheduled to take place in person in Los Angeles thereafter. The depositions will take place at the offices of the attorney taking the depositions. The depositions of plaintiff's experts will occur before those of the rebuttal experts. We have tentatively scheduled Dies for July 21st, subject to his availability. We look forward to a productive call on Friday. Okay, so that was Kim's. And huh. Okay, sorry. So whose lawyers? Which one? I gotta look it up because I'm like, okay, Kim Zeldin. Okay, obviously. Hello. Blasted. What did I just do? Is this usually sufficient enough? Like, I kind of wish that this email had a response back by the lawyer of Stephanie Jones, because this is just a synopsis of the conversation that she claims that they had. But I really would like to see what the response was from Stephanie Jones's lawyers. Was there like at least some sort of acknowledgement? Because I was hoping that we would get an email that shows that they, in their words, in their way. I'm hoping there was something like that. So interesting. I don't know. With that said, I think that's all I have for tonight. I feel a little bit tired, and I need to wake up tomorrow morning to head into work. Or I'm trying to leave earlier these days. But it was great to spend time with y'all. Let's look at that. One of my short ones, just a little over an hour. You know. Have a great night, y'all. Bye.